Shall we start? All
Sure. Why
right.
not?
Well, thanks everybody for tuning in, and thank you, Kevin Bress, for presenting today. Looking forward to learning lots of stuff. So, thank you. I think if you're eating lunch, go ahead and mute, and, and that's what I'm going to do. So I'll turn it over to Kevin. Thank you.
All right, Brian, thank you.
How do I mute it?
So I'm going to share my screen, and we can certainly, with this small of a group,
Touch screen and look for the mute button.
if somebody wants to ask a question by unmuting, I'm fine with that, instead of trying to do it through the chat box and all that formality stuff. So today's topic has a lot of focus on trusts, because that's something that I hear people asking about all the time, and sort of the goal to unravel the mystery of trusts. So once I get my bearings here. Okay, so a little definitional background. What is a trust? And it's equivalent to being like a legal entity. And it exists by virtue of a trust agreement. So that's often where the lawyer comes in, because somebody puts a blank screen in front of themselves and they're going to say, how do I make a trust? You know, what do I do here? So they need a little help there. It's done pursuant to state law. So a Maryland trust might look or have some different aspects to it than a Delaware trust or a Florida trust. They generally all recognize each other's laws in states, but Florida, as you can imagine, is particularly difficult to have a non-Florida trustee. So if you form a Florida trust, they want a Florida trustee. And that's sort of a barrier to entry. I wonder if that could be challenged constitutionally. So I liken a trust to these other entities that exist because of the laws. You form a corporation, you have an estate, you have an LLC. These are all entities that by the graces of our legislature are allowed to exist. Now you'll hear trusts being given all sorts of names, and that those names are not really legal names, they're descriptive names. So if you say, oh, I want to have a special needs trust, well, there is no law that says something is a special needs trust by the terms of the law. It's more, what does that trust accomplish? And a special needs trust is one to allow a beneficiary of a trust to qualify for public benefits that are asset driven, like you have to have low assets, but yet you can have a trust with lots of assets and get the best of both worlds, the trust and the public benefit. So that's a special needs trust, just by example. So the formation is done by a person or persons called the grantor. You might hear the term settlor, but generally that's who signs the written agreement creating the trust. So they establish the trust. The trust could be established immediately. So we nickname that a living trust, because you're signing it and you want it to go into effect. Or young parents will do something called a testamentary trust in their will that says, hey, if we young parents die and we have young children, very young children, we may want the children's inheritance to be held by a trustee under a trust. So that's the opposite of a living trust, is a testamentary trust. All right. So why have one? Well, that's the question. I get people all the time. Kevin, I need to see you for estate planning. Yeah, what do you want to do? I want to have a living trust. Why? Well, I don't know. Susie Orman said I should have a living trust. So that's not quite meeting my standard for doing it yet. I mean, it may be fine, but let's figure out what you're trying to accomplish, and then see if the trust is the best vehicle for you. So let's keep talking about what a trust is. It has certain elements. We covered the grantor. The trust is managed by a person we call the trustee, and that can be one or more trustees, and they're given the control. It's like the grantor hands the steering wheel over to the trustee and says, okay, this vehicle is now for you to drive and control. And then sitting in the back seat of the vehicle are the beneficiaries, and that's for whose benefit the trust exists. Now, to learn a little bit of trust vernacular, we have the corpus of the trust, also called the principal. So if I put $1 million in my trust, to start, I have funded the corpus, the principal of the trust. And the trust then is invested, usually making money. So that's the income, obviously, of the trust. It could be interest and dividends, for example. Capital gains is not always considered income. It's more of the corpus growing. And then if interest and dividends stay in the trust after the end of a calendar year, then that element of income is converted to principal of the trust. Let's talk a little bit about the trustee. In legal terms, the trustee owns the assets in the trust. And that's a little scary to the grantor, because if they sign their house over to a trust and the trustee is their child, and somebody says, oh, the trustee owns the house, the grantor parent is like, wait, I didn't mean to give away my house. But that's not the situation. So I put here one analogy. A corporation can have a president, and the president basically owns and runs the corporate assets, but it's for the benefit of the stockholders of the corporation. So in this case, the trustee has to follow the terms of the trust. They don't own anything. But if that property were to be sold by the trustee is the one who goes to settlement and signs the deed. So there's something in a trust where we create a fiduciary duty in the trustee. So the trust is saying whoever is acting as trustee has a duty to act in the best interests of the beneficiaries. Okay, and so I think I kind of covered that. Beneficiary, and that's the bottom line. That's who is this trust for? That's who's going to benefit. And you can have primary beneficiaries and you can have contingent beneficiaries, meaning the primary dies and then the contingent will step into the primary's shoes. Just because you're a beneficiary doesn't mean you have all the rights in the trust that you would like to have. You're not just entitled to scream and holler that I want money from the trust. It must follow the terms of the trust agreement. And that leads to a very common set of terms that lawyers use in trust agreements as to when a beneficiary is entitled or gets income or corpus. We usually use a standard of health, education, and support. So the trust will say the beneficiary is entitled or may receive, I should say, money from the trust for health, education, and support. But we give the trustee the pure discretionary power to decide whether the beneficiary's need for support, because that's pretty broad, right? Support is pretty much anything. Vacations, new house, wedding. So it's up to the trustee. And the law recognizes that when a trustee has broad discretionary powers, it's not to be litigated or argued by the beneficiary. They are at the mercy of the trustee. Now, if the trustee says, I'm not giving you any money because you really angered me last week, that is unreasonable, depending how long they carry it out. If they go for a year saying you're not getting any money, then the beneficiary could probably win in court. So we have primary beneficiaries, and the danger to a trustee who has a fiduciary duty, the trustee also has a duty to the contingent beneficiaries, even though their vesting of an interest doesn't occur until the death of the primary beneficiary. So the trust is for the children first, and when the children die, the trust is for the grandchildren. This is important because the trustee has to watch for both of these parties. If the trustee gives all the money out to the primary beneficiary, and the primary beneficiary takes it to Atlantic City predictably and loses it, don't the contingent beneficiaries have a legal action against the trustee saying you shouldn't have given all my contingent interest in the trust to my parent who went to Atlantic City and blew it? So trustees, be careful. You've got to think through what could go wrong in carrying out your fiduciary duty. Clearly, you follow the purposes of the trust, but there are other laws the trustee must follow. Income taxes, trusts that make money have to file income tax. The form is just one digit higher. We file 1040s, trusts file 1041s. And they generally report to the beneficiaries their share, if any, of the income. So the income then is invested. I shouldn't say the income, the corpus is invested. And so all the usual types of investments come to mind: stocks, bonds, mutual funds, and so forth. Well, there's a whole body of law that trustees must follow, sort of a prudent investor standard. So they can't be overly speculative in these investments like Bitcoin. Not doing so well, the old Bitcoin right now. And they certainly can't loan themselves money. The trustees say, well, I need a new house. I'll borrow $300,000 from this trust. I'll pay the trust 5-6%. Hey, that's a good deal for the trust. No, that's called self-dealing. And if the trust owns real estate, that's a higher standard too, because you have to maintain the real estate. Can't let the pipes freeze in the winter when it's vacant, that sort of a thing. When is a trust actually in existence? Merely signing it doesn't necessarily create the trust until the trust is funded. A funny thing in the old days was you would see a literal dollar bill stapled to the last page of the trust to show that that trust is now in existence because it has a dollar in it. Not sure what that really was supposed to accomplish because, oh, I know why. If you have a trust with nothing in it, it's a bucket. It's an empty bucket. Then you have a will that says, when I die, take all my assets from the will and give them to the trust. Well, there was a worry that if the trust didn't exist, the will couldn't pour the money into a non-existent bucket. So we staple a dollar to the bucket, and now we have an existing trust. Well, the law changed and said, don't worry about stapling the dollar to the trust. If you have a signed written trust agreement, you've got a trust, and the will can pour over the assets to the trust. It won't actually function until it has assets, but it does exist. So a final point before we look at actual types of trusts would be trusts can be lifetime or at death. Just a review, a living trust is set up now by a grantor, and it's very common that the grantor is going to also be the trustee and the beneficiary. So we call it a revocable living trust because the grantor controls his own, her own destiny in that trust. They can give the money to themselves, they can terminate the trust. And so you hear about a lot about revocable living trusts, and we will cover that. The second version is you die. And often a testamentary trust is actually built into the will. So the terms of the trust, the actual trust is in the will. So I'll have clients call me and they'll say, yeah, I have this trust that my dad left me. And I'd say, oh, well, can I read the trust instrument? Well, that throws them off because they say, well, we never found a trust. We don't think there is a trust. I say, does he have a will? Yes. Well, lo and behold, on pages 8, 9, and 10 of the will is the trust. So the trust can exist inside a will, resident inside the will. A little more about the revocable trust. We covered this aspect that the trustee is also the beneficiary and can give money to themselves. And because of that, the grantor's social security number is used for all the investments and the income, meaning the grantor treats the trust almost invisibly as their own money for income tax purposes. So that seamless aspect of the trust is helpful because while the grantor is alive and well, they don't want to file a separate trust tax return. And because the IRS says if you are the grantor and the beneficiary, I should say, if you are the trustee and the beneficiary, it's your money and don't file a separate tax return. And state law also says it's your money. So if you're the grantor, trustee, beneficiary, you've accomplished nothing in terms of protecting money from a nursing home, protecting money from a lawsuit, and so forth. So the revocable living trust is not the vehicle where you're looking for asset protection. It is still exposed to what could go wrong for the grantor trustee person.
So Kevin, the question would be, what is the benefit of the living trust?
And I'm going to circle back, Steve.
Good. I try to segue for you, Kevin.
You did. And it's coming attractions right after, the intermission, which we're not going to have. So I had the revocable trust first, and then I went with irrevocable because that's sexier to people, oh, wow, this really does a lot of good stuff. So the irrevocable trust, some people will establish one of these while they're alive, not a testamentary trust after they're gone. Why set up an irrevocable while you're alive? So it's a grantor who relinquishes control to a different trustee and is also to a different beneficiary. So that's kind of different, that they're not their own. Oops. I just hit the wrong button. So we'll get back to it. There we go. They're not their own trustee. They're not their own beneficiary. So why do they do that? They're trying to insulate their own assets from things that can go wrong in life, such as being in a nursing home for 5 years. So who do they choose? Well, most traditional family setups, they're going to name a child or children to be the trustee of this irrevocable trust. Now, here's the part that scares everybody away. The trustee is not allowed to give money to the grantor. The person who put it in the trust cannot get it back. It's irrevocable, not just because you cannot amend it, but it's also because you gave away your money and you can't have it back. So who is the trust for? Well, typically the children could take the money out of the trust for themselves. And then if the grantor were to be sued or go to a nursing home, the child has the control of the money. If the parent 3-4 years down the road, being perfectly healthy and fine, says, I'm out of money, and turns to the child and says, you've got my money in that trust and I need some of it. Well, the trustee child cannot write a check to the parent. What they can do is write a check to him or herself. And then the child can go, a couple months. Hey, mom, hey, dad, guess what? I've got a lot of extra money. I don't have to tell you where I got it, but I have some money. I'll give it back to you. I'll give you money. So as lawyers, we cannot build that into the terms of the trust, that the child may take money out, then give the money to the parent. And we have to be a little bit sneaky about it. We don't want to take 10,000 out of the trust and then give 10,000 to the parent and do that 5 times in a row, because we're then thumbing our nose at the government someday when the parent says, I don't have any money. And the government says, well, what are all these deposits of 10, 10, 10, 10,000? Oh, my child gave me those. There wouldn't be a trust, would there? Let's see the records of the trust, minus 10, 10, 10, 10, 10. So you can see, if we want to respect that this trust does not give money back to the parent on a routine, if any basis, if we can possibly help it. So here's an example of when the, I'll call it lifetime irrevocable trust is put into what it does. So we have our, basically our grantor here, call him Fred Mertz, and Fred puts money in trust and he names little Ricky as the trustee. And so what we show here is that the child may use the trust for the benefit of, well, basically the child can take money out for themselves, as we said, and notice I don't draw any arrows or show in any way the money can come back to Fred. And when Fred dies, the trust pays out to the children. So somebody might realize, wait a minute, why are we doing all this trust business? Can't Fred Mertz just give the money to the children and say, hold my money for me? Well, the lawyer points out, hey, your children can get in their own jackpot. They can get sued, they can get divorced, they could pass away. And where is your money, Fred? Where's your money going to go if you just gave your money to your children instead of keeping it in the protected irrevocable trust? Now, I have a lot of clients who will use this trust vehicle for just their home. So these are more senior folks, maybe 70s, who are thinking, you know, one day, or my home's very valuable, and one day I don't want to lose my home because of needing long-term care. So they put their home in the trust, and it's not likely the children trustees are going to kick the parent out of the home, because now they remember legal title in the trustee, children. So the children could say, Fred, get out of the house, we're going to sell it. But in reality, that might happen because Fred might have half burned down the house 2 or 3 months in a row with leaving a pot on the stove and the fire department, you know the picture. So sometimes I hear stories of, you know, the children kicked their parent out of the house and threw him in a nursing home because they owned the house. Well, what's the backstory on that? The backstory is dementia with the parent, serious problem. So I don't villainize the children so quickly when I hear that story. So the money can also be put in trust. And my advice to my clients is never put money in an irrevocable trust if you expect to need it later. Now, nobody has a crystal ball to have an exact formula for that. But if the parent's worth $500,000, and meanwhile they're living on their Social Security and their fantastic government pension, their money keeps going up, not down. So they might take $200,000-300,000 of the $500,000 and say, I don't think I'll ever need to dip into this money. That's money they could put in the trust. Why? Because if they do run out of money, or I'm sorry, if they do end up in a nursing home, they would rather just run out of the money they have left, qualify for Medicaid, and not have to touch the trust money. And then there's a whole theory of, besides the nursing home concept, is heirs, the people you leave your money to, they can lose the money that you gave them. They can get into their own jackpot. So if you leave money to a child and the child ends up getting divorced, then potentially half of the assets you left your child could be taken by your in-law, daughter-in-law, son-in-law in the divorce. So we're going to talk about a trust that protects the child's inheritance that way. Okay, I had a client this week who was 100 years old. And how old are the children now? 70 something. So a child can become disabled and the parent could leave the money to the child in trust so that if the child ends up in a nursing home themselves, they're not going to lose their inheritance from the parent who one day left them their legacy. A child could die, and if your child dies and leaves assets to the usual person, it's their spouse. So your child's spouse is your in-law. Well, if you have grandchildren and you're leaving your children all your money, wouldn't you like to see your grandchildren inherit your money, not your daughter-in-law or your son-in-law? So a trust can protect from that happening. You leave money to family who gets sued from a car accident, and it goes way above their insurance. Now the inherited assets can be taken. And I won't talk about death taxes because right now you have to have more than $10 million if you're married in order to have a death tax under federal or state estate tax laws. So the tax thresholds are very high right now before you're taxed on your net worth. The government may lower the threshold someday because the tax base is really shrinking, but we'll save that for another day. All right, so I call this the 5 Ds of what can go wrong, and you see why. So how do you protect? Well, before we talk about protect, let's just run a review of how assets pass at death. There are really just 3 ways your assets pass when you die. You set them up jointly owned. So if you're married, typically you own your home with your spouse. And when one dies, the survivor just owns the house, plain and simple. The second way you own assets is you designate a beneficiary of those assets. The most common beneficiary asset is your life insurance. You die, the surviving child even could file a claim and get your life insurance. It does not involve any governmental intervention. And other things that call for beneficiary are IRA, annuities, bank accounts that are called, banks give you a document called a POD, a pay on death. So you could actually fill out a form at the bank that's almost like a will. It says, "Dear bank, when I die, give my money to my 3 children." POD. And the cousin to POD is TOD. That stands for transfer on death. And so the law created 2 different terms. Investment companies use the TOD. Banks, savings and loans, credit unions use the POD. And then there's something called a life estate deed. That's getting a little more tricky, but you can set up a deed so that at your death, the named people in the deed inherit the real estate, whether it's your home. Now, if you have out-of-state property, this is a very valuable technique to use. Just record a new deed so that your Florida property, your Delaware property passes to the beneficiary and it doesn't have to go through box number 3. So box number 3 is the default. If it's not joint and it's not beneficiary, then it's an estate asset when you die. Something's got to own your assets when you die. It's your estate if it doesn't pass automatically. So the estate, how does it get from the estate owning your asset over to your beneficiaries? It goes through a process called probate. So a person is appointed to be the executor of your estate, appointed by the orphans court. And typically the will names who that executor is going to be. But if you don't have a will, then you're intestate. the laws of intestacy. And the government has chosen a hierarchy of who is going to be in charge of your estate if there's no will. Typically, spouse and children together are the default executors of your estate if there's no will. So hopefully everybody moves over to the will side of things, and then they file all the forms with the government that they have to, and eventually the assets, maybe 7 to 10 months later, get distributed to the beneficiaries. If one of the beneficiaries is deceased, then the will typically say, leave it to my grandchildren, the children of the deceased beneficiary. But what lawyers try to do with estate planning is ask a bunch of questions. Well, what if these guys are 7 and 10 years old? They're minors. Who's going to control the money when they're minors? So the will, we read further, and it could say, well, set up a trust for the minors, and my other 2 children will be the trustee of the minor's money, or one of my children, or maybe the spouse of the deceased child. If they've been married long enough, you love your spouse as much, if not more, than your own child. So you say they're smarter with the money, they're better with the money. Anyway, that's what a will does. It lets you figure all these things out. All right, so this was all the prelude to showing you how we now interject the testamentary trust into this equation. That was where we were trying to protect the money from the 5 things, the 5 Ds of what can go wrong. So we modify this estate plan, and we modify it over here. So we have the will, but in the will, we leave the money to a testamentary trust, not to the family people, but instead to the trustee of a trust. And I wrote the word temporary because the trust will collect all the assets in the estate from the will, from the estate, from the, how'd that get to be box 4? That's supposed to be box 3. Can't fix it right now. Okay. So the assets come around and they go into the trust. Some people can do a shortcut by designating the trust as the beneficiary of those certain accounts. So now you have a trust. Let's say you had 2 children. It splits into 2 shares, 1 for each child. And the trust continues. If you're fine with your children managing their own money, as most people are, then we let the children be their own trustee, and they can use the money for those terms that we alluded to before: health, education, maintenance, I threw in, and support. And then your trust can provide that upon a child's death, the money goes to their children, the grandchildren. Remember, I was saying, do you want your in-law to inherit, or do you want your grandchildren to inherit? So you can spell out where this trust share goes, or, and most people will, give their children the power to override you just in the event that the grandchild's, a certain grandchild might have special needs, or grandchild just in a bad way, substance abuse, in prison, whatever. So we want to give some flexibility, because you may be long gone as this trust share goes on and on and on. So that's a testamentary trust protecting assets for the next generation. Doesn't protect it for you, because you have to die first before there is a testamentary trust. All right, now back to the question. Why have a revocable living trust? What is good about it? Well, first you have to understand that when you set up a revocable trust, in theory, the grantor no longer owns the asset. The trustee owns the asset. So that's important, because if the grantor loses capacity, the trust has a successor trustee to step in and take over managing the grantor's money. So in other words, the trust hands off control to somebody else when mental capacity is lost. Now here's where somebody's hand can shoot up and they say, but Kevin, there's a document called a power of attorney. That allows a person, we call an agent under the power of attorney, that does the same thing for incapacity. The agent steps in and manages the trust. I'm sorry, the assets. So let's differentiate these two. Let's look at power of attorney and compare it to revocable trust here. So the first question is, what if you name somebody in your document and they no longer can serve and there's no alternate? So under power of attorney, if there is no person left under the power of attorney to serve, the power of attorney document is useless. It's gone. And so the family might have to go to court and have a guardian appointed. Whereas under a revocable trust, the document will spell out a daisy chain of how to keep picking successor trustees on and on and on. So there is a mechanism to ensure that trustees are always lying in wait to step in, where in a power of attorney, you can't change it or add a name after you're incapacitated. What if the document is, as somebody's trying to act for you and they're trying to use your document and the document doesn't allow you, doesn't specify that you can do that certain thing. So in other words, under a power of attorney, suppose you're trying to sell real estate and the power of attorney doesn't mention selling real estate, which in fact it always does, but that's just my example. Where then the agent can't sell the real estate because it wasn't a power expressly conferred in the power of attorney document. Compare that to a revocable trust. If the real estate is owned by the trust, there's no way the trustee doesn't have power. They have power over the trust. So you have better protection. These are sort of one-off things that are weird to happen, but it does point out a distinction between the two documents. What if you die? Well, under a power of attorney, the agent's out, no more authority. Power of attorney dies with you. Whereas under a revocable trust, it might become an irrevocable trust, but at least the trustee or successor trustee, if you were the trustee who died, can take over. And so there's no interruption in managing the assets, at least the ones that are in the trust. When can the fiduciary act? So if you have a power of attorney and you name a child as your agent, well, they could act as your agent the next day. Maybe you don't want them to act yet because you're fine. You're able to manage your own affairs today. Well, that's where the trust is a little better, because as long as the grantor is the trustee, the backup trustee has no power. So some people like that. And then what about the assets after death? Well, under a power of attorney, there's no express way those assets get addressed. They either go into probate, unless, as we saw, that box 1, joint owner, box 2, beneficiary, or by default, box 3, the assets under a power of attorney go into probate. Whereas under a trust, the assets were owned already by the trust, and so they continue to be owned by the trust after death. And then the terms of the trust kick in. So just a little primer there on the differences with these two important ways to manage your assets. Any questions? I'm on a roll here. Okay, so upon death, the revocable trust normally is going to become irrevocable, because when you set up a trust and you die, you don't want somebody else to come in and start monkeying with what your wishes are. And your wishes may be to just go ahead and distribute the trust immediately to your family. And the trust can do that because it's not held up in the probate process. So that is an advantage of the revocable trust. It speeds through, cuts through the red tape of government. Assets might not even have to be appraised if they're passing to family members who are tax-free, which again, most family situations are, given how high the estate tax thresholds are before you're taxable. And some people like the idea that a trust can be completely private, whereas a will is public knowledge. Mark and I were on the phone a little while ago talking about how he wanted to look up somebody's will. And the register of wills said, yeah, go online and click, 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 pay a few bucks, and the will is delivered to your inbox from a deceased person's estate. The will is public knowledge, whereas a trust can remain private. Negatives of a trust. Why doesn't everybody have a revocable trust? It sounds like it does all sorts of great things. Well, you have to change the ownership of your assets to the trust. And for real estate, that's going to involve some money. Typically, a lawyer's drafting a deed, the county's charging a fee, the title company's recording the deed. So, and then not to mention the drafting of the trust. So trust could be in the $2,500 range in order, when there's real estate involved, to get everything set up. Then people will do a trust, but then over time they kind of forget and they get new assets or they trade assets and they forget to keep them in the trust. And they end up having probate for those other assets that they forgot and didn't get into the trust. So it's sort of self-defeated part of the planning. And then there are assets that cannot even go in a trust. Retirement money, because it's not been taxed yet, the government says it has to stay in the non-taxable vehicle, IRA, 401k, 403b, 457, has to stay in the taxable vehicle. And it can't go in the trust until you withdraw it and pay the tax.
Question. So you have 401k or IRA, whatever it might be. What if it's a Roth IRA, which has already had taxes taken out?
So the beauty of a Roth is every year it makes money, it's tax-free. If you try to put a Roth in a trust, you have to take it out of the Roth and it's not going to earn money tax-free anymore.
Hmm.
So you're still out of the Roth environment to get it into a trust.
Got it.
And then if you want to change your trust, you may be back in the lawyer's office because it's confusing. How do I change a trust? How do I amend it? That's not really that expensive when it's a minor change, but still it's additional cost. Although wills, you have to pay to play on that too, to change it. Misconceptions about the revocable trust. So Susie Ormans, she's on TV saying the trust is the best thing since sliced bread. And in some ways, maybe, but let's dispel some things that it doesn't fix. It almost sounds like, oh, if I have a revocable trust, then I have nothing that goes through probate. Well, there are plenty of assets that could go through probate and the trust can't deal with them, like unusual. Let me give you the most unusual, but it's a vivid example. Somebody is killed, God forbid, with a car accident or medical malpractice. Well, the estate sues for the deceased person and the estate recovers the money and it goes through probate. So just because you have a revocable trust doesn't mean you have a complete avoiding of probate in that case. A minor item would be a person dies, they cancel the health insurance, they cancel the car insurance, they cancel the homeowner's insurance, and all these checks come in the mail. Estate of Kevin Bress, estate of Kevin Bress. Well, they have to be probated, those checks. You can't cash them, and the trust can't cash them. So you never just automatically avoid probate simply by having the trust. If I'm sued the trust is protected, false. These are all misconceptions. So these are all false. If I go to a nursing home, my trust assets are protected, not in a revocable trust, because the government says you can revoke the trust and you can get your money out. So you're not protected. After death, the beneficiaries won't know who gets the money from the trust. I guess that's not as artfully worded as I thought when I typed it. In other words, do the beneficiaries get to know who's getting what in the trust? The answer is yes. It's not a secret anymore as to those beneficiaries. It's not public. It's not in the Register of Wills website, but it's public among the beneficiaries because there's a trustee duty to share the information with who the beneficiaries are because they can't keep that a secret. I do a revocable trust. Now I don't need a will. False. You always should have a will because there are things that you could inherit or get after you die. Believe it or not, you can inherit after you die. So the will would say what to do with it. I did a revocable trust, so I guess I don't need that power of attorney anymore. No, you still need a power of attorney. Even though the trust is a power of attorney itself on steroids, great, but the trust can't authorize my spouse to call Baltimore Gas Electric and change the service, or my child is a better example. My child can't deal with my business stuff, companies, using a revocable living trust. They need to have a power of attorney. If I lose mental capacity, the power of attorney takes over running the trust. Now that's just there to clarify. It's the trustee who takes over running the trust at that point. So, summary, the revocable trust avoids probate. You can put your belongings in the trust, household belongings. That's a savings of an appraisal when you die. How do you put your piano in the trust? We just fictitiously say on a piece of paper, I hereby assign all of my belongings in my house to my trust. And the law recognizes that. If it went through the estate, if it went through the will, then the Register of Wills says, well, how do we know that's not a Steinway or a $10,000 bow on a violin, that sort of thing. So you can skip that with a trust. And then we have one to show that you can protect your assets from a second marriage in a revocable trust. This is a huge issue that I see, believe it or not. And here's how it plays out. We have Mike and Carol Brady, and they are the Brady bunch. I didn't give them all those kids. I just gave them a couple kids each here. So Mike has 2 kids. Carol has 2 kids. They're a happy couple. They've been married for years and years and years. They do their typical estate planning documents and they say, Mike says, at my death, give all my money to Carol. Why? Because when Carol dies, I know she's going to take care of all 4 children as if they were hers down here. So Carol says, I promise you, Mike, my will never vary. It will leave everything to your 2 children and my 2 children. Now, several years later, Carol inherits and she suffers a stroke and Carol has to go to a nursing home. Carol's children consult with an elder law attorney and the children say to the lawyer, Mom is going to lose all her money to the nursing home. And so the lawyer says, well, quick, grab your mother's money and protect it from the nursing home. And so they, using power of attorney, perhaps, they're able to grab Carol's money and put it in their pocket. And Carol goes on Medicaid. Several years later, Carol dies and she has no money. And in fact, what she did give to the children, about some of it, half of it, let's say, was spent at the nursing home. But the rest of it, the children were able to preserve. Well, Carol's gone. Mike's children show up. Where's their dad's share? Why aren't they getting an inheritance? And Carol's children say, well, we were able to protect mom's money, but sorry, we couldn't protect your dad's money. That's the money that went to the nursing home. And off they go running with the money. And here's Mike's children chasing them down the road for the money. All right, that's not fun. So what could the revocable trust have done here? So Mike and Carol could have said, you know what? We have blended families here. Let's put all of our assets in a joint revocable trust. And so at one death, like Mike's, let's elevate one or both of his children to be a co-trustee with Carol in this revocable trust. Now that's a tall order for Carol to have to put up with, now having a stepchild riding side saddle over her assets, her house, her money. But this is what you got to do, because I see it happen where Carol could get dementia down the road and do things that Mike wouldn't want her to do. So later, if Carol does need the nursing home, and we do that same plan where we're going to take all her money and shield it from the nursing home, we involve all 4 children now. Why? Because the 2 children from Mike are part of the equation. They are trustees. And so they have a seat at the decision table. And now Mike's children would be protected. That's just a quick how the trust can protect things. The revocable trust at death becomes sort of like a testamentary trust. And so all the things we talked about a testamentary trust doing for the inheriting children are the same for that, as well as the, within the revocable trust. And with that, I'm going to leave it to questions. You can certainly email me a question if you don't want to get too detailed in this venue.
I just had a situation last week where I handle pretty much everything from my mother now. She's going to be 95 in June.
God bless.
And she was leasing a vehicle up until she stopped driving. And then we figured that because the price of used vehicles has gone up so much, we were going to be leaving a lot of money on the table by her just turning that car back in. So she wanted to, well, we advised her that she wanted to buy that car at the end of the lease term, and then we'll dispose of it. And, we're going to make about $6 or $8 grand on it. But she doesn't really leave the house very much. So I went and, gathered all the documents and everything, took my power of attorney that you wrote, Kevin, and went to the MVA and did the entire transaction for her. She didn't have to be there. And it was that power of attorney in this case that allowed me to do that. And it's actually, the MVA has a pretty good website on how you do all this stuff. And so I walked in with all my stack of things that I needed, and 30 minutes I was in and out, and it was done deal. So those documents really do come in handy.
Yeah, I had a similar case when Lisa, my wife, was working, and this was years ago, and we were getting her a new Ford Taurus or something, and I went into the dealership with the power of attorney, bought the car in her name, and then took out all the loan documents in her name. That was a great feeling. I drove off with a new car, and it didn't cost me a cent.
Oh my.
And you reminded me, Mark, really wasn't part of this presentation, but as long as you brought up MVA, they have on their site a beneficiary designation for a car. It takes a little noodling to find it, But for $20, click, 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 you will get a new title in the mail, and it'll say beneficiary on the title.
Hmm.
That's huge, especially husband and wife, where they don't have their car jointly owned and one dies. They want their spouse to have the car. They don't want the spouse to have to go to court to get the car.
Right.
Yeah.
Interesting. But if you buy it jointly, it's a moot point, right?
Yeah, I mean, some lawyers who do more of this work than I do will tell you jointly owning a car with a spouse opens up a little more liability risk, because if I can sue both owners of the car,
Oh.
I can get your house. That assumes you don't have enough insurance, but yeah,
Yeah. Well, we got an umbrella thing.
good.
So-
Yeah.
Should
Yeah,
cover
umbrella
that.
insurance is great. Yeah.
All right.
So I have a question. So then, like, when I bought my house, I was not married. And so the house is still only in my name. I should have it retitled with my wife and me to make it easier.
A, to make it easier, and then B, there's also this liability protection for a jointly owned house. If one of you causes an accident and their car accident and there's $1 million judgment, they cannot take a jointly owned house away from you. If you're the one who causes the accident, Brian, then your house is at risk if the insurance falls short.
Gotcha. So then do I go like back to the bank to add her name?
No, draft a new deed and just record it. And an attorney can, or a title company can do that for you.
Okay.
My guess is you're in the $500 range, just to give you an idea. That's with the court costs, when I say court, land records, and a title company recording it for you if you use one.
Okay. Thank you.
So Kevin, in the trust, can you designate, like, obviously you said you can designate to children, family members, whatever. Is it only in the will, or does the trust also have the ability to make like a donation to a nonprofit?
Yeah, you can have a clause in a will or a trust saying upon the deaths of one or both spouses, right off the top, give $10,000 to the shul or United Way or whatever. Yeah.
Okay.
There's a lot to take in.
So,
but-
Kevin, you didn't mention anything about, you mentioned something about transferring money a couple of times, a couple of your examples, transferring to the kids to protect it from the nursing home or whatever. And it could be state invoked as far as differences in how things get addressed. But for Medicaid, that's national, as I think about it. So the question I'm getting to here, it concerns, I heard about a 5-year look back law on transferring money. So it's really not protected unless you have that 5-year window.
I was waiting for you to give me a segue so I could get into that. Yeah, so there's a whole Medicaid overlay of rules. And Steve, you hit on the concept that if you're putting money in an irrevocable trust to protect it from the nursing home, you're only going to get 100% protection if you did it 5 years before needing the nursing home or going into the nursing home. So that makes a case for doing this trust well before you think you really are about to need it. And that's hard for people. That's why you don't see too many of these trusts, because people don't wake up and say, you know, Marge, I think I'm 5 years away from the nursing home today. Let's run down and set ourselves up a trust.
I don't know. Today was a tough morning.
I'll start drafting one for you.
Uh,
Hi, Kevin.
Hi, Rhonda.
I had a question. Richard and I, over the last 2 years, moved from Pennsylvania. We had a will written in Pennsylvania, power and attorney and all that. Is there anything we have to do now that we're living in Maryland?
Well, the will from Pennsylvania, I would guess, is fine, because there's not that much different in laws from state to state that would make a will a problem from another state. So that one, still, it doesn't hurt to have it read by a lawyer here, just to bless it for your peace of mind. Powers of attorney are a different animal. Maryland has its own power of attorney document that the legislature wrote. And the legislature said, if you follow our document, then when a Mark Wolko goes to MVA and tries to use the document and they say, sorry, we don't like powers of attorney, and he calls his lawyer and says, they're not taking my power of attorney, the lawyer can say, well, then they're liable for your legal fees if I have to make them honor your power of attorney. So my point is, Maryland power of attorney in Maryland is extremely valuable. Pennsylvania power of attorney in Maryland may not have that same force and effect.
Okay, thank you.
I guess
And
we're all
okay,
gonna do this.
and how frequently, Kevin, do you recommend we all look at these documents for a refresher?
Yeah, I arbitrarily throw out 5 years, 10 at the most. And if you had a lawyer do it, chances are you might even just get away with a phone call back to that same lawyer to say, hey, Charlie, you did all my stuff. Anything happening in the law that I got to come in and redo it? And of course, Charlie, the lawyer, should say, okay, nothing, but did anything happen in your family that, oh yeah, my son now has been diagnosed with blah, blah, blah. So then it's like, uh-oh, we better look at that. So yeah, a conversation can tease out an issue. But a lot of times, law for me has not changed since 2010 in any material way with power. That's when powers of attorney were rewritten in Maryland, 2010.
Cool.
Well, any other questions for Kevin, or should we all just make appointments with him now?
I'll put up my calendar.
We have your number.
Plug ourselves in there. Well,
Thank you, Kevin. That was good. Good review.
All right, thank you.
on behalf of Adult Ed, thank you again for doing this presentation, and we'll put the recording up so those that missed can watch it, because that was amazing. It's given me lots of stuff to think about. So
Yeah.